Madam President, I couldn't agree more with my colleague from Rhode Island and his eloquent statement, and my colleague from Maryland. And I think we're going to be hearing a lot about this Roberts Court as we head into and during the Kagan hearings. I rise today to talk about Americans' basic right to have their day in court. The Supreme Court has always been a towering institution, both physically and metaphorically. And until recently, as visitors walked up the steep steps of the Supreme Court's front doors, they entered underneath a mantle inscribed "Equal Justice for All." Now those bronze doors are closed to the public. Now that may have been because of security concerns, but it's hard to imagine a better metaphor for what has been happening to our court. The Roberts Court has consistently denied hardworking people their day in court, blocking them from their entrance to the courtroom. Many of you remember my talking here on the floor about Jamie Lee Jones. As a 20-year-old, she went to Iraq as a contractor for KBR, then a Halliburton subsidiary. She complained about sexual harassment almost immediately. She was put in a barracks with 400 men and a handful of women. When she complained to KBR, they not only ignored her, they mocked her. They told her, "Well, go spend a day in the spa." 4 days later, she was drugged and brutally gang raped by her coworkers and then locked in a shipping container with no contact with the outside world. What happened to Jamie Lee in Iraq is bad enough, but because of the Supreme Court's decision in Circuit City Stores v. Adams, KBR had been able to force Jamie to sign an employment contract that required her to arbitrate all job disputes rather than bringing them to the court, to a court of law. So Jamie, now a teacher in a Christian school in Texas, was forced to spend the next 4 years fighting to get her day in court after being gang raped on the job. She's had 2 reconstructive surgeries since this happened. Let me say this again. She was brutally gang raped on the job and still had to fight just to get her day in court. I am proud that the Senate passed my amendment to give victims like Jamie Lee Jones a chance for justice, and was proud to see it signed into law. But sadly, we're about to see a lot more Jamie Lees denied their day in court. Just yesterday, as Senator Whitehouse talked about, the court erected yet another hurdle for people seeking justice in another 5-4 decision, this one called Rent-A-Center v. Jackson. On one side of the courtroom in this case was Rent-A-Center, a corporation that runs over 3,000 furniture and electronics rent-to-own stores across North America with 21,000 employees and hundreds of millions of dollars in annual profits. On the other side stood Antonio Jackson, an African-American account manager in Nevada who sought to bring a civil rights claim against his employer. Jackson claims that Rent-A-Center repeatedly passed him over for promotions and promoted non-African-American employees with less experience. Although Jackson signed an employment contract agreeing to arbitrate all employment claims, he also knew that the contract was unfair, and so he challenged it in court. But yesterday, the Supreme Court decided with Rent-A-Center, ruling that an arbitrator, not a court, should decide whether an arbitration clause is valid. Let me say that again. The arbitrator gets to decide whether an arbitration clause is valid. Let me repeat that. The arbitrator gets to decide whether the arbitration clause is valid. That's just one step away from letting the corporation itself decide whether or not a contract is fair. In doing so, the Supreme Court made it even harder for ordinary people to protect their rights at work. Justice Stevens, not surprisingly, wrote the dissent. And like he did in Gross, Stevens notes that the Supreme Court yet again decided this case along lines, quote, neither briefed by the parties nor relied upon by the Court of Appeals. In other words, the Supreme Court went out of its way to close those bronze doors and keep them closed. Clearly, this is a ruling that Congress needs to fix, and I look forward to working with my colleagues to do so. Sometimes it's easy to forget that the Supreme Court matters to average people, to our neighbors and our kids. Some have tried to convince us that Supreme Court rulings only matter if you want to burn a flag or sell pornography or commit some horrendous crime. But as Jamie Lee Jones and Antonio Jackson show us, the Supreme Court is about much more than that. It's about whether you have a right to a workplace where you won't get raped, and whether you can defend those rights in court before a jury afterwards. It's about whether corporations will continue to have inordinate power to control your life with their armies of lawyers and their contracts filled with fine print. It's about whether they can force you to sign away your rights in an unfair employment contract so you never see the inside of a courtroom. It's quite frankly about the kind of society that we want to live in. Next week, the Judiciary Committee will hold hearings on the nomination of Elena Kagan to the United States Supreme Court. Those hearings provide a good opportunity for us to examine the legacy of the Roberts Court and talk about what it would mean to have a court that instead cares about hard-working Americans. Solicitor General Kagan is nominated to fill the seat currently occupied by Justice Stevens, who wrote the impassioned dissent in yesterday's Rent-A-Center ruling. I hope that General Kagan has learned from Justice Stevens and takes his words to heart. I look forward to questioning her during these hearings. I want to make sure she understands that Supreme Court cases impact all of our lives, and that she will be the kind of justice who believes in equal justice under the law.